Assalamu alaikum everyone. My name is Zainab. The topic which I would explain today is that mediation under section 89A of CPC. So firstly we talk about that what is section 89A. Section 89A was inserted into the CPC to address the serious problems in the civil justice system, especially huge backlog of cases, long delays in deciding civil suits, high cost of litigation, and overburdened courts. Traditional litigation was slow and often damaged relationships between parties. Now we will talk about that what is ADR. So ADR refers to methods like mediation, conciliation, arbitration and negotiation. These methods focus on settlement rather than judgment. Then we talk about that why ADR was needed. ADR was introduced to ensure speedy justice, reduce burden on courts, provide cost effective solutions, and promote access to justice. This also has constitutional support. ADR supports Article 37D of the Constitution, which is that speedy and inexpensive justice and fundamental right to fair and due process. 89A lies in the urgent need to reform the civil justice system. ADR was introduced to make justice faster, cheaper, and more humane without compromising legal rights. Now we will discuss the mechanics which refer to mediation and the process. The first one is court referral. So, referral to mediation is usually made after the willing of the written statement. At this stage, the court can assess the nature of the dispute and chances of settlement. Second one is court satisfaction. The court must be satisfied that dispute involves private rights such as property, contract, family, and commercial disputes, and the matter is capable of settlement. Third one is consent of parties. In practice, court seeks to consent of both parties. Also, Section 89A empowers the court. Mediation works best when parties participate voluntarily. Another one is appointment of a mediator. A mediator may be a person agreed upon by the parties, appointed by the court, often a lawyer or trained mediator. And next, the stay of court proceedings. Once referred, trial proceedings are stayed. This allows parties to negotiate freely without litigation pressure. And then the end is settlement agreement. After mediation, if settlement is reached, mediation submits a settlement agreement. If mediation fails, mediator submits a failure report. If successful, court records settlements and disposes of the case. If unsuccessful, case returns to the court for normal trial. Settlement recorded by the court has the force of the decree. It is binding and enforceable. So, the referral mechanism under Section 89A CPC is a structured process where the court acts as a gatekeeper, ensuring only suitable cases are sent to the mediation for speedy and amicable resolution. Now we will discuss that advantages and the challenges or limitations in practice. Firstly, we will talk about the advantages. So, cases are settled faster than traditional court trials. The first advantage is that speedy resolution. For example, a property dispute that could take 5 years in a court may be resolved in a few months in ADR. Second, this is cost effective process. Saves money on court fees and prolonged legal expenses. Third one is maintains relationship. Mediation encourages cooperation and compromise, preserving family, business, or social relationships. Next one is voluntary and flexible. Parties have control over the outcome and settlement terms. Unlike court judgments, mediation is customized to the needs of the parties. Another one is confidential. Discussions and settlements are private. Unlike court trials, they are not public records. And another one is reduces court burden. Diverts suitable disputes away from the courts, reducing the backlog of cases. Binding and enforceable. Settlement recorded in the court has legal familiar to a decree. Now we will talk about its challenges and limitations of mediation. Dependence on parties cooperation. Mediation depends on parties cooperation. Mediation only works if parties are willing to negotiate sincerely. If one party is uncooperative, the process can fail. Second one is lack of awareness. Many lawyers and litigants in Pakistan do not fully understand mediation. This reduces its uses and effectiveness. Third one is no compulsory outcome. Mediator cannot impose a decision if parties don't agree, trial continues. Another one is time constraints. Court set time limits may not be sufficient for complex disputes. Another one is quality of mediators. If the mediator lacks skills or experience, mediation may fail. And it is not suitable for all cases. Cases involving criminal matters, public law, or complex legal issues are generally unsuitable for mediation. And also, it faces enforcement challenges. While settlements are binding, enforcing informal terms to outside the recorded agreement can be difficult. So, in conclusion, mediation under Section 89 ACPC is highly beneficial for civil disputes, offering speed, cost, savings, and amicable settlements. However, its effectiveness depends on the cooperation, awareness, mediator quality, and the suitability of the dispute.